It was a decision that sent shockwaves from the marble steps of the Supreme Court in Washington, D.C., straight into the legislative chambers of all 19 state capitals. In an era defined by a deeply divided nation and an equally divided court, something unprecedented just happened. The justices came together in a rare moment of absolute unanimity, a 9-0 ruling. And in doing so, they didn't just tweak a law around the edges. They fundamentally dismantled a legal architecture that has governed firearm ownership in the United States for over a century. You are watching because you heard the headlines. You heard words like panic, shakeup, and historic. But if you are like most Americans, you are probably asking yourself a very specific question right now. Does this mean I can walk into a store tomorrow and buy whatever I want, or does this actually change nothing for me at all? Here is the question I want you to hang on for the next few minutes, and I genuinely want you to answer in the comments below. Is the elimination of permitting, training, and waiting periods a victory for constitutional freedom, or does the disappearance of those requirements make your community less safe? I want to see where you stand on this. Let's cut through the noise. For the last 2 years, since the court's landmark decision in New York State Rifle and Pistol Association versus Bruin, America has been living in a state of legal limbo. Lower courts were confused, legislators were angry, and gun owners were caught in a whiplash of conflicting rulings. One day a law was valid, the next day it was gone. But this new ruling handed down just days ago changes the game entirely because it applies strict scrutiny to the Second Amendment for the first time in living memory. Think about what that means for a second. Strict scrutiny is the highest bar in constitutional law. It's the standard we usually reserve for fundamental rights, like free speech or the right to vote. To pass strict scrutiny, a government law doesn't just have to be a good idea. It has to be proven to be essential to public safety and the absolute least restrictive way to achieve that goal. Historically, lower courts treated the Second Amendment like a red-headed stepchild, often using a much weaker standard called intermediate scrutiny, which basically meant that if the government had a half-decent reason to restrict guns, they could do it. That world is over now. The ripple effects of this 9-0 decision are immediate and violent in the legal sense. Of course, we are already seeing 5 major categories of gun control laws collapse like dominoes across the country. And the panic in states like California, New York, New Jersey, and Illinois is not hyperbole. It is a legal reality. Let's start with the most controversial piece, the death of the May issue permitting system. In states like New York and New Jersey, the law was written to give local law enforcement or judges near total discretion over who gets a concealed carry permit. You could pass the background check, take the training, and be a model citizen. But if the local police chief wrote in a letter that he didn't think you had proper cause or a specific need to defend yourself, you were denied. The Supreme Court killed that concept 2 years ago, but many states simply ignored the ruling or created new laws to circumvent it. This 9-0 ruling is the hammer. It clarifies once and for all that subjective discretion has no place in the permitting process. If you are not a prohibited person, the state cannot invent a reason to keep you disarmed. But that is just the tip of the spear. The second category being wiped off the map is the mandatory training requirement. Now, let's be careful here because this is where the nuance matters. The court did not rule that training is bad. In fact, the justices acknowledged that training is highly beneficial. However, the court ruled that the government cannot use mandatory, costly, and often inaccessible training courses as a barrier to entry to exercise a constitutional right. If a state requires you to pay $500 for a specific course that is only offered twice a year in a city 3 hours away, and you cannot get your permit without it, that is functionally a poll tax on your Second Amendment rights. Those laws are gone. Then there is the waiting period. Does anyone remember the logic behind the waiting period? It was originally called the cooling off period. The idea was that if you were angry and went to buy a gun to do something terrible, a 3-day or 10-day wait would allow your temper to subside and prevent a tragedy. Emotionally, that makes sense. Legally, this court just ruled that it is unconstitutional. By a 9-0 margin, they decided that delaying the delivery of a lawfully purchased firearm imposes a burden on the law-abiding citizen that the government cannot justify using the new historical standard. This is also where the fourth category comes in: fees. The age of the $200 application fee is over. The days of paying hundreds of dollars just for the privilege of applying for a right are over. The court made it clear that fees must be nominal. If the cost of a permit is prohibitive for a low-income citizen, that law is no longer valid. And finally, the fifth pillar that has crumbled involves sensitive places. Many states, after the Bruen decision, tried to turn their entire states into gun-free zones. They defined nearly every square inch of public space as a sensitive place where carry was banned. The Supreme Court looked at history and said, no, historically, sensitive places were carouses and legislative chambers. They were not public buses, parking lots, or convenience stores. The ruling today strips away those blanket prohibitions. So you're in thus. This brings us back to the human impact. I want you to stop and imagine a single mom working the night shift in Los Angeles. She wants to protect herself on her commute home on public transit. As of last week, she was likely committing a felony if she had a firearm on her person. Because of the ruling this week, the law that said she couldn't defend herself is likely unenforceable. Conversely, I want you to imagine a police officer in rural Illinois. He pulls over a driver for a traffic violation. The driver hands over a permit issued in a state with virtually no background check or training requirement, a permit that must now be recognized in Illinois. The officer has no idea if the person sitting in the car actually knows how to safely handle the weapon they are carrying. That is the new reality of constitutional carry. Before we go any further, this is the part of the video where I usually remind you to hit that like button. But more importantly, if you want to stay ahead of these rapid-fire legal changes, because they are changing daily in the lower courts right now, please hit that subscribe button. We are tracking every single lawsuit, and I promise you the chaos in the lower courts is just getting started. Now, let's talk about the legal mechanism that made this happen, because it is actually the most important part of the story. It has to do with the case known as United States versus Rahim, which was decided in 2024. Wait, hold on. Some of you in the comments might be screaming at your screen right now. Rahim was the domestic violence case where the court upheld the ban on guns for people under restraining orders. Yes, that happened. But here is why Rahim is actually the gasoline on the fire I am describing today. When the Supreme Court decided Rahim, they taught the lower courts how to do the Bruen test. Before Rahim, lower courts were striking down almost every gun law because they demanded a historical twin, a law from 1791 that looked exactly like the modern law. In Rahim, the court said, no. You only need a historical analog, not a twin. But, and this is the killer, the court also said that the government must prove that the law is relevantly similar to historical traditions. In the ruling we are covering today, the court took the Rahim framework and applied it to the licensing schemes we discussed. The government tried to argue that shitty laws from the 1700 seconds, where you had to post a bond if you were a dangerous person, justified modern permitting fees. The court rejected that. The government argued that militia training requirements of the 18th century justified the modern mandatory classes. The court rejected that too because the historical laws applied to everyone in the militia, while modern training applies only to civilians trying to exercise a right that the Heller decision called individual. Think about the implications for reciprocity. Right now, we are watching the federal government debate the Constitutional Concealed Carry Reciprocity Act. That legislation would force every state to recognize every other state's permits. The anti-gun states are terrified of it. But guess what? This 9-0 ruling just made that bill almost redundant. If the Supreme Court is ruling that no state can require expensive training or subjective approval for their own residents, the argument for forcing them to recognize other states' permits becomes a much easier lift. The legal principle that a right cannot be burdened by geography is now squarely on the table. But let's not be naive. The panic in the blue states is real, but it is not helpless. We are already seeing attorneys general in states like Hawaii and Maryland pivot to a new strategy. They have read the tea leaves. They know they can't ban the gun and they can't tax the permit. So what are they doing? They are regulating the ammunition and the carrier. You're going to see a massive push in the next legislative session toward micro-stamping laws for bullets or insurance requirements. For example, the court might say you don't need a permit, but you must carry liability insurance. Or the court might say you can carry a gun, but it cannot have a magazine that holds more than 10 rounds because that isn't a bearable arm historically. This ruling is not the end of the fight. It is just the beginning of round 2. And here is where the history gets really dark, and we have to be honest about it. The dissenting justices, and yes, there were 3 opinions written, even though the vote was 9-0 on the narrow question, warned that the majority is ignoring the reality of 21st century violence. They pointed to the fact that we have over 300 million people in this country, now not 3 million. The historical tradition of 1,791 involved single-shot muskets and a nation that was mostly wilderness. The idea that we should be shackled to the horse and buggy era to regulate weapons technology is to the dissenters an act of judicial activism that will get people killed. I want to pause right here because this is critical. The 9-0 ruling I am discussing today applies to licensing and permits. But there is a second unanimous ruling that dropped in the same week that has caused almost as much panic, and it has nothing to do with the Second Amendment. I am talking about Montgomery versus Carib Transport 2 LLC, the trucking case. You might be asking why a trucking case matters to a gun law video because it reveals the court's current attitude toward federal power and deregulation. In Montgomery, the court ruled 9-0 that freight brokers can be sued for negligent hiring of unsafe truckers. Why does this matter? Because the same legal logic could be used to sue gun manufacturers or dealers who sell to straw purchasers. The freight broker case stripped away immunity. That same legal theory is currently being teed up to strip away the Protection of Lawful Commerce and Arms ACTA, which is the federal law that currently gives the gun industry sweeping immunity. If the court is willing to expose shipping brokers to liability, the legal firewall around the gun industry just got a lot thinner. Let's bring this back to your doorstep. What does this mean for you if you live in a restrictive state? If you live in New York, you need to be watching the docket of the Southern District. Within 48 hours of this ruling, lawsuits were filed asking judges to void the state's new Concealed Carry Improvement Act in its entirety. Specifically, the provisions that ban carrying in Times Square, in subway subway stations, and in places of worship. There is a very high probability that within the next 30 days, a federal judge will issue a preliminary injunction blocking those enforcement provisions. If you live in California, the sensitive places law that banned carry in 26 different categories of locations like parking lots and libraries is effectively dead. The state knows this. Governor Nuomi has already announced he is exploring enhanced background checks that go beyond the federal NICS system, attempting to use state-level databases to catch prohibited persons who slip through the cracks. But he cannot stop the carry of the firearm itself. If you live in Illinois, the repeal of the waiting period is going to hit hard. The city of Chicago, which has some of the most restrictive laws in the nation, is currently scrambling. They are looking at ordinances that ban ghost guns and 3D printed firearms because those are not technically firearms under some definitions. This is the cat and mouse game of constitutional law. But what about the rest of us? The 43 states that already had fairly permissive laws. For you, this ruling is a stabilizer. It means that if you travel from Texas to Florida, you don't have to worry about accidentally driving through a jurisdiction that requires a special permit. It means that the reciprocity of your rights is more fluid. We have to talk about the elephant in the room, the dissent. Justice Thomas, in his usual fashion, wrote that the majority didn't go far enough. He wanted to strike down the background check system entirely. Justice Alito warned about the chaos of allowing states to simply rename their restrictions. But it was Justice Ketanji Brown Jackson's concurrence that was the most haunting. She basically told the lower courts, "Good luck. She admitted that the Bruin test has resulted in a 455% increase in Second Amendment challenges and that the system is, in her words, unworkable. That is the quiet part that everyone is missing. This isn't a victory lap for the Brown side, and it isn't a funeral for the gun control side. It is a jurisdictional bomb. The Supreme Court just told the states, you cannot regulate this way. But they didn't tell them how they can regulate. That means every single state legislature is going to go back into session and they are going to invent new laws. We are going to see laws about carry while intoxicated become more strict. We are going to see laws about storage and safes become mandatory. We are going to see red flag laws, ERPOs, aggressively used to disarm people who haven't committed a crime but are deemed a risk. Rahim gave the government the blueprint to keep guns away from dangerous people. Now, states are going to define dangerous very broadly. If you have ever been involuntarily committed for a mental health evaluation, even if it was 20 years ago, you may find yourself on a list. The 9-0 ruling on permits is just the sugar to make the medicine of expanded dangerous person laws go down easier for the public. So here is where we stand. We have seen the collapse of the 5 pillars of restrictive gun control. We have seen the application of strict scrutiny, and we have seen the trucking industry lose its immunity, hinting at a future where gun manufacturers might lose theirs. The Supreme Court has acted unanimously, which means there is no political partisanship to blame here. There is only the Constitution as they see it. Before we wrap up, let's clarify the line between fact and speculation. What is fact? The requirement for May issue permits is gone. The requirement for mandatory training classes as a prerequisite for ownership is gone. Excessive application fees are gone. Broad sensitive place designations are gone. These are factual outcomes of the rulings. What is speculation? Whether this will lead to more violent crime. The criminologists are split. Some studies show that right to carry laws correlate with a reduction in violent crime because criminals fear armed victims. victims. Others show a correlation with an increase in aggravated assaults because tempers flare and a gun is present. We do not have the data yet on this specific ruling. If you see a video telling you that crime is going to drop by 50% tomorrow, that person is lying to you to sell something. If you see a video telling you the streets will run with blood, that person is also lying to you to get views. The truth is much more boring. It will vary by zip code, and we won't know for 3 to 5 years. What is confirmed fact? Every single one of the 50 states is currently in non-compliance with this ruling. The attorneys general of the restrictive states have a choice. They can rewrite their laws in a week, or they can fight injunctions for the next 5 years. Given the 9-0 margin, they will likely choose to rewrite the laws. Watch for emergency legislative sessions called in New York, California, and Illinois within the next 14 days. We also need to look at the Wolford versus Lopez case that is waiting in the wings. Hawaii is trying to ban carry-on private property without the owner's express permission. The Ninth Circuit upheld that ban, but after this 9-0 ruling, the Supreme Court is likely going to take that case and squash it immediately. If the court rules that you don't need a permit from the state, you certainly don't need a sign from a landlord to walk into a shopping mall, that case is the next domino to fall. Let's take a step back and look at the philosophical shift. For 40 years, the gun control movement operated under the public health model. They treated guns like cigarettes or dangerous drugs, something that could be regulated into near invisibility through taxes, licensing, and advertising bans. The Supreme Court has just ruled that the public health model cannot coexist with the Second Amendment. The Second Amendment is a civil right. It sits alongside the right to free speech and the right to be free from unreasonable searches. You cannot tax the right to speak. You cannot require a license to vote, and now you cannot require a permit to carry a weapon. This is the great unwinding. Over the next 6 months, as these injunctions roll out, you will see headlines about loopholes. The media will call the removal of permitting a loophole. It is not a loophole. It is the law. The media will call the ability to carry without training dangerous. That is an editorial opinion, not a legal fact. My job here is to separate those two things for you. I want to leave you with a vision of the future that most channels aren't talking about. The real battle is moving from the state level to the local level. If the states cannot pass laws, the cities will expect to see a massive increase in civil liability ordinances. San Francisco might not be able to ban your gun, but they might pass a law that says any business that allows guns on premises is liable if a shooting occurs. That will force private businesses to ban guns, shrinking the sensitive places mapped through the free market rather than through criminal law. Expect to see safe storage laws enforced with daily inspections. The state might not be able to stop you from buying it, but they can fine you $1,000 a day if you leave it on your nightstand. Legal disclaimer. This content is provided for educational, informational purposes only and does not constitute legal advice. Laws regarding firearms are subject to frequent changes and vary significantly by jurisdiction. You must consult with a qualified legal professional in your state to discuss the specific application of these rulings to your personal circumstances before taking any action. The bottom line is this. The panic in the state capitals is justified. They just lost a century of legal precedents in the span of a single ruling. For the first time in history, the right to bear arms, meaning the right to carry them outside the home, is on equal footing with the right to keep them inside the home. Think about what the dissenting justices said, that the majority is living in a fairy tale, ignoring the bloodshed of the modern era. Think about what the majority said, that rights are not subject to a cost-benefit analysis. Where you land on that debate defines who you are. But here is the question I need you to answer in the comments now that you have the facts. Knowing that the waiting period is gone, the permits are gone, and the fees are gone, would you feel safer walking down the street tonight or less safe? I am not asking for a political fight. I am asking for your gut reaction. I read every single comment. This is not the end of the Second Amendment wars. This is the beginning of the first true test of the Bruin framework in the real world without the training wheels. I will be back on the channel tomorrow with a breakdown of how to legally carry in New York City under the new rules, because the rules are changing by the hour. Until then, stay informed, stay safe, and I will see you in the next.